44, and you can also email us at lawcall@wnbb.com. As we mentioned earlier, we're going to be talking about family law, but before we get to that, we have a quick email question that we're going to discuss regarding a personal injury question that came in. I think they'll have that up for me. I had a wreck earlier today and everything happened so fast, I'm starting to wonder whose fault it really was. I know I shouldn't say I know I shouldn't say that to the other guy's insurance adjuster, but is it safe to say that to my own insurance company? And that is from Kay. Kay, that's a very good question. As we always say, the old adage, anything you say can and will be used against you in the civil arena just as much as in the criminal arena. And whereas clearly the other guy's insurance company is an adversarial opponent, your own insurance company can be in certain aspects. For example, as we've talked many times on this show, one of the coverages that you have on your policy is uninsured motorist coverage. And in that situation, that is coverage that stacks on top of the at-fault party's insurance. And so in that situation, your insurance company is standing in the shoes of the person that is actually responsible for the accident and therefore would be adversarial or opposite to you in that particular situation. It's important to not get down the wrong path early in a claim. And there are many things that can be done to make sure and gather the proper evidence so you can have a clear picture of what actually happened in the accident. As we've mentioned, there's many times cameras and different angles. There's witnesses that may be available. So it's important to get in touch with somebody that can help you gather that information and properly analyze the case and make sure you start out on the right path right from the start, because once you get off on the wrong path, it can be very difficult to right the ship. So make sure and reach out to a law firm that has the resources and the tools that can assist you to make sure you do that properly from the get-go. And if you do, you have a good chance of making sure that claim is processed not only successfully, but in a timely manner. So, Kay, please make sure and reach out to us, and let's hope that you can get that claim done successfully. So now we're going to turn to a little bit of family law, and I am pleased tonight to introduce Clark Rogers. Clark, I believe it's your first time on the show, correct?
First time.
Clark, if you would, just briefly tell the audience a little bit about yourself, where you work, and what you do.
So my name is Clark Rogers. I work over at Burke & Blue. We've got a full-service law firm over there. If you got in trouble with the police, we can't help with that. Other than that, we can help. I started practicing civil litigation right out of school and sort of matriculated over to family law, and I maintain a real estate practice on the side as well.
Very good, very good. And you know, family law has many different aspects to it.
Certainly.
I know we were talking briefly before we got on the air about some things that are coming down the pipeline, in particular with respect to some rights that grandparents may have. And I know just anecdotally from law school, I can remember in the past, grandparents had very limited to no rights with respect to their grandkids. What's kind of the current status of that law and potential changes that are coming down the pipeline, Clark?
So the changes that have come down the pipeline, you know, it still is the case that there are very limited circumstances in which grandparents can have actual custodial rights. They can petition for those on a temporary basis if there are exigent circumstances. They can also, you know, petition for those rights in the event of the child being taken into the Department of Children and Families custody. You know, grandparents are typically going to be given priority in that kind of circumstance. And then in the event, the most recent change, I believe, DeSantis signed into law, I want to say August of last year. If one parent is deceased and the other parent is found criminally liable, therefore, then grandparents can step in and say, we'd like some custodial rights, please.
Right. Well, and that seems to make sense in those situations, that you want to have somebody close to the family. I'm sure that they're looking out for what's going to be the best interest of the child.
Absolutely. And you can't say that phrase often enough in the family law arena, Ted. It's best interest of the child, best interest of the child, best interest of the child.
Well, and that's the two things I remember, equitable distribution and best interest of the child. That was the answer to everything.
That's what they told you when you're studying for the bar?
For the bar exam. But, you know, in addition to the grandparents' rights, I remember, you know, just the old adage that I always was led to believe growing up was that essentially in a custody dispute that the mother was always going to win, that the father was behind the eight ball. And is that really the case?
Well, historically, that has been the case. You know, historically, that has been the case, and depending on where you live, that, you know, may or may not still be the case. But up here, you know, up here in the Panhandle. I think the statewide, essentially what the law now holds is no presumption,
Right.
no presumption one way or the other, which, you know, a lot of judges are taking to mean I start from 50-50 and I go from there. If you've
Right.
got a good reason to deviate from 50-50, then you know, we're willing to listen. But as a general rule, they're starting to trend more towards you know, equal time sharing or something resembling. I mean, the public policy of the state, the judges, of course, are well aware, is frequent and continuing contact with both parents. So it can differ on a family-by-family basis depending on what your schedule is, depending on, you know, if one parent's working, you know, one parent's
Right.
not working, things like that can lead to a non-50-50 kind of arrangement. But the good news for the male viewers is they're a little bit less behind the eight ball than they historically have been.
Right, and that should be the case. You want whatever is best for the kids in the particular circumstances,
Absolutely.
and that should be a case-by-case scenario, not some presumption of one or the other.
Absolutely.
I know another question that frequently gets asked, just in passing, and is what are the parameters and how do you determine alimony? Is there a formula that automatically gets thrown here? Is there a time of years that makes a difference? How does that kind of work out in the state of Florida?
So in the current setup, the law basically sets this up to where you have short-term marriage, and that's anything 7 years or less. You got a medium-term marriage, anything between 7 and 17 years. And then you've got anything over 17 years considered a long-term marriage. And the way the law works right now is anything over 17 years, long-term marriage, we just assume that it's going to be permanent alimony if it's appropriate to award alimony in the first place. You first have to make that threshold showing of one party has a need for alimony and the other party has the ability to pay alimony. You know, if they're both making $50,000 a year, it doesn't matter if, you know, they've been married 20 years or 30 years. You know,
Gotcha.
probably not getting alimony in that circumstance. As far as how it's calculated, right now we're in the somewhat unfortunate position of there aren't really guidelines that we can go on. It's just, again, need and ability to pay. And I'm fond of, you know, telling my clients, well, need is very much in the eye of the beholder.
Yeah.
You know, somebody might be, you know, have a $5 million estate and they might be entitled to alimony, and somebody might have, you know, a lot less than that, and they say, well, we don't really have any need because we look to the marital standard of living in terms of determining need. But coming down the pipeline, possibly there's some changes to the alimony bill. I believe sitting on Governor DeSantis' desk right now is Senate Bill 1416 that would establish some more specifics in terms of how that's calculated.
I got you, and I've heard that there may be some parameters coming down the pipeline where they may eliminate the ability to have permanent alimony, i.e. you couldn't get it indefinitely into the future. There would have to be some set certain time frame.
That's exactly right, Ted. The new law, if signed by Governor DeSantis, and it has been passed now by both the House and the Senate as of very recently, so you know, general thinking is this one actually has a pretty good shot of passing. The last couple got vetoed, but essentially the way that this would work is it would do away with permanent alimony. The long-term marriages, you would now be, the maximum duration you could get would be 75% of the length of the marriage. For medium-term marriages, 60% of the length of the marriage, and then for short-term marriage, no more than 50% of the length of the marriage. And then stacked on top of that, the legislature has also established a way to calculate the actual amount, which, you know, actually provides us some firm guidelines when we're asked that question. And basically it would be 35% of the difference between their net incomes.
Okay, so taking some of the discretion away from the trial court and kind of putting some
Providing a little bit more structure.
parameters on what you can do, what you can't do.
Exactly.
Well, that's good. Well, just remember we got those phone lines open, 850-392-1544. You can email us at lawcall@wnbb.com. We'd love to answer your questions on any of these topics related to family law, or any periphery issue. If you have it, just make sure and give us a call and we can take care of that. But I know, Clark, you know, family law has a lot of different aspects. There's obviously we've talked a little bit about alimony, we've talked a little bit about child custody. What about when the parents have now divorced, they're separated, there's these child custody agreements in place or judgments.
Sure.
What happens when one of the parents now wants to move and leave and go and change the residence potentially of the kid? How does that work in that process?
Well, so it depends. That's my favorite answer, and the answer is going to be it depends. If you're moving if you're moving less than 50 miles away, that's typically not going to be considered a substantial change in circumstances to justify changing the child custody arrangement. It can be, depending on the surrounding circumstances, but anything less than 50 miles, typically parents are able to just move around as long as it's not going to materially affect the access arrangement that's currently in place. Now, if you're wanting to move more than 50 miles, and it's again 50 miles in a straight line, not as you wind down the road, but if you want to move more than 50 miles, we have a different statute, section 61.13001, that establishes some parameters you have to follow to ask the court for permission to actually move. It's petition for relocation. And there may be the least fun thing in family law, because there's no room for compromise there typically. Right. There's going to be a winner and there's going to be a loser. Either you can move or you can't, but the short version is if you want to move more than 50 miles, you have to either get the other side's permission or you got to get the judge's permission.
Well, I know that can be a difficult situation to do, and life happens and people move, but you always have to think at the end of the day it's the best interest of the child that's going to be the preeminent choice of the judge, or the preeminent factor in the judge making that decision.
100%, always and forever, best interest of the child, best interest of the child, best interest of the child. It's unfortunate because most of the relocation cases you see involves a service member on one side or both sides. Then the judges are placed in some really, really tough positions in those circumstances, obviously.
Are there any special factors that come into place when you're dealing with a military member, or are they treated just like any other member of the public?
They're treated just like any other member of the public. They're subject to the same factors, and by and large, the court will look at such things as, all right, is the move going to improve the educational opportunities for the child? Is the move going to improve the financial circumstances of the child? What have the historic roles of the parents been? If you have one parent who hasn't been super involved historically, then they're a little bit, the judges are a little bit more likely to move the child away in that circumstance. When you've got two parents who are very, very active and involved, then it's a lot, tougher thing to do.
Right. And I know that's got to be a tough situation to be put in.
Absolutely.
For either of the parties in that.
It's a tough one. The goal of family law typically is and should be to settle the case. The system is reasonably predictable once you have enough information. So I'm fond of saying your goal should be to settle the case. Because most people would rather spend money on themselves or their children than on, paying us to do what we do.
Right.
And once here's a range of what's likely to happen, let's settle within that range. That's possible in most cases. In the relocations, it's just typically not going to be possible, right?
Yeah, that's tough. Now, I know I hear the term community property state versus what we are here in Florida.
Right.
And if you would just briefly explain the difference between those two forms of property division.
So here in Florida, we don't have we have community property. We classify it in terms of marital or non-marital. Right. And a lot of people will, come into my office and say, like, well, this is titled in just my name, or like, well, I got this, at this point in time. We don't really. We can care about how something's titled, but generally what the court's going to be looking at is when was it acquired? Was it acquired during the marriage, or was it acquired not during the marriage? And that's not a hard and fast rule. Something can be not acquired during the marriage, and then you take certain steps to make it marital property, such as retitling it. And if you receive property during the marriage and it's in the form of a gift or inheritance, and you keep it segregated in its own account and don't commingle it with other marital property, then it may retain its non-marital characteristic. But generally what we care about in the state of Florida is when was it acquired. If it's acquired during the marriage, it's probably marital.
What about something that you inherit, for example?
Yeah, an inheritance, a common fact pattern is somebody inherits something and then they put it in the account with all the rest of the money, and now I can't tell what's what, so right. It becomes marital. And I guess the problem that people run into is they get the inheritance and they don't know that divorce is coming, so they just do what they would normally do with it, which is putting in checking or whatever. But generally, if you keep the inheritance in its own account, or if you keep it segregated, or you keep it titled the way it was titled when you got it, it's typically going to retain its non-marital characteristic.
Okay, even if it's inherited after the marriage.
Even if it's inherited after the marriage.
Okay, so the simple point is if you segregate it and keep it separate, inheritance will potentially not become a part of the marital estate. If it's commingled, then it's split up and subject to equitable distribution, just as a general rule.
As a general rule, yeah, the case law carves out a lot of exceptions and, you know, if-thens, but as a general rule, that's absolutely correct.
Well, and then another term that I hear frequently is that Florida is a no-fault divorce state, and what does that mean, just as a general rule?
Well, it basically means you don't really have to prove who's at fault, as the name would imply, when you're splitting up the stuff or deciding custody issues and things like that. If somebody's at fault in a way that affects the best interest of the children, then maybe we're wanting to listen to the circumstances. Surrounding the breakdown of the marriage. But as a general rule, the court's going to assume that there's enough blame to go around. So they don't typically want to hear that much about the circumstances leading up to it unless it has an effect on the money, the stuff, or the children. Anything else, just plead the marriage is irretrievably broken, no further explanation required, and you're entitled to a divorce.
Very good. And you just said something that it really isn't relevant unless it deals with the money. So that would be, for example, just use an example, theoretically, if you had a mistress and were giving her money and wasting assets away,
right.
At that point in time, does that become relevant in the property distribution?
Absolutely, absolutely. As a general rule, we're not going to look at the circumstances, but if you are have an adultery kind of situation and you're spending money on hotel rooms or whatever, buying gifts, jewelry, things like that, and it has an effect on the marital estate, the amount of stuff to be split up. Typically the money that you spent, on the misconduct is going to be charged against their side of the column when it comes time to split up the stuff. I got you.
So as a general rule, you're starting with equitable distribution, and there's going to need to be some exception to take you away from that.
Correct. We start with equitable. Typically is going to mean something like equal, but if there's been misconduct or if there are other extenuating circumstances, that's not always the case.
What are some of those other factors outside of the monetary dissipation? Is there anything else that could potentially factor into that?
Sure. So, for example, if it's not possible to do an exact 50-50 arrangement without selling the marital residence and splitting up the proceeds, but the kids, the court finds it's desirable for the children to continue living in the house they've always lived in. They may, say, for example, all right, well, sorry, it's not going to be exactly 50-50. Right. We find it's preferable for the children to remain in their house.
All right. We're going to take a quick break. Those phone lines are open. Please give us a call, 850-392-1544. Welcome back to Law Call, and over the break we had an email question come up. If you would pop that up on the screen for me, please. A family member dropped her child off with me about a year ago and disappeared. Now the grandmother has custody a year later. I never had custody of the child, but can I press charges against the mother for abandoning the child or get her for child support for her child I raised for a year? And that is Michael. I will let Clark answer some of the family laws issues here. I mean, most of the criminal issues, pressing charges, that's ultimately the decision of the state attorney's office whether or not they pursue any charges and whether there's proper grounds for that. But with respect to the custody issues there, I mean, just having that happen, is that
well? If you had a formal custody agreement, what most people call custody, means I have physical, not possession of, but the child lives with me.
Right.
There's a difference between that and I have an actual custody agreement. Right. And actually, Florida doesn't even speak in terms of custody anymore. We speak in terms of time sharing and so forth. But the short version is, if you had an order, then maybe you could go after her for child support.
Absent that,
all other things, probably not.
So it's important if you need those to get those legal rights taken care of. I think we have a caller now, Terry. Terry, go ahead with your question, please.
Gary, my question is, my wife recently died, and I wanted to know if there's particular things I should do because of that fact that she is recently passed away, and I need to take care of our business.
Right. Well, Terry, first things, condolences on the passing of your wife. I know that's a very difficult situation, and then trying to figure out what to do moving forward. Typically, it'd be good for you to go ahead and sit down with a probate attorney to see what assets may need to be probated. Depending on how you had your assets titled, there may be the possibility that they passed automatically by operation of law. So it's important to go sit down with someone. If she has a will, find the will, take that with you. If not, it's going to be through an intestate, which means without a will, you as a spouse will have a large portion of the rights. But first, go see them so you can make sure and see what you need to do to start that process in order to figure out how to get things that may not be titled in your name transferred appropriately. We're going to go to break here, but we'll be back with additional questions. Welcome back to Law Call. We're going to go right straight back to the phone lines. I believe we have an Amy. Amy, if you would, go ahead and ask your question, please.
My question is that my daughter suffered mental illness, and I'm the grandmother. She gave her rights to me. I raised the child from birth to 16 years old, and the father, after proving he's the biological father, wanted custody of the child. He's taken custody of the child presently right now. I wanted to know what can I do after my daughter had given me custodial rights, and for the child was raised in a Christian home. How can I get custodial rights restored to me?
Okay, Amy. And Amy, this is a situation dissimilar to that earlier email where Amy actually had legal rights from the court. But now the father has come in and stepped in. Does that change the analysis here?
I think it does change the analysis, Ted. And unfortunately, Amy, it's going to be difficult for you to get custody back if the court's already made that determination. If the father petitioned through a circuit court and the court said, you know, we're finding it's proper to return the child to the custody of the father, then you may be able to file a petition in some very limited circumstances. But typically, they're the sorts of circumstances that would warrant getting the Department of Children and Families involved. The court's not going to step in the event of disagreements over religion or over something like the child's not doing as well as we would hope in school. So unfortunately, I'd say definitely consult with an attorney to get the facts more fleshed out and consult with somebody regarding what your rights may be, but probably you have a difficult road there. And just to, I guess, just to add to that a little bit, the unfortunate part about custody litigation is it can take a while.
Yes.
Things especially when you're talking about children, everybody really wants to get it right, and because we really want to get it right, and because our courts are overburdened and underfunded, quite frankly. It unfortunately can sometimes take a while to take a case all the way through the system. So the fact that the child's already 16, you're already under the gun.
2 years, yeah.
Right. It can take every bit of 2 years to get a custody case pushed through.
And it's real sad because there's a lot of times situation where kids have been with the grandparents. The grandparents are that stable force, and then a parent comes back, and there's just this presumption that the parents are going to be the ones that have the kids.
Until very, very recently, grandparents had essentially no rights, as we talked about at the beginning. The tide's starting to turn a little bit more in the direction of grandparents, and judges, all other things being equal, they love grandparents. They encourage that. We want those relationships to flourish, but in terms of legal rights, they are few.
Right. Well, that's all we had time for. We didn't really we ran through our shout outs, but we're going to go with just one shout out. Paul and Tracy Martin, my good friends I got to see there this last Friday, but we'll be back with you next week with another show. It'll be two of us from Perry and Young.